Hello and welcome to a special presentation of the Tennessee Informer. I'm your host, Dave Vance. Our guest tonight is Jeff Cobble, an attorney and more importantly, an expert on the Constitution and one of the main authors of the Restoring State Sovereignty Through Nullification Act, Senate Joint Resolution 9005, passed in October of 2021. And the thrust of the resolution was whereas assertions of a federal authority whereas if the federal government intends to overreach its authority to the point that it assumes the traditional constitutional role of a state legislative body, it is only fitting and proper that the very existence as well as the depth and breadth of this federal power be condemned and challenged, not just in a court of law, but also through the actions of the General Assembly to nullify such federal overreach. Now, I'm not sure what's changed in the last 3 years. That resolution passed unanimously in the House and the Senate. Almost every Republican senator voted for it. And as far as I know, every Republican senator on this committee, with the exception of Adam Lowe, who was not in the Assembly at the time, supported this resolution, as did almost all Republican members in the House. But in any event, despite the fact that 2775 and House Bill 2795 would have gone through a legal process before being filed, we have an AG's opinion. So here tonight to discuss that AG's opinion is Jeff Cobble, the attorney who helped write this legislation. Jeff, how are you tonight?
I'm very well, thank you, Dave.
Well, thank you for being with us. I know you've got a lot on your plate, and I just really appreciate you taking the time. I want to just get right down to it. So what are your responses to the AG's opinion?
Well, let's deal first with what the AG opinion says. The opinion is summarized on the first page. It's see, what is it, about a 4-page?
Yes.
4-page opinion.
Right.
And as you said, it references last year's bill numbers, but the question is Senate Bill 1092, again, that would be 2775
right.
today. Is it constitutional, essentially? And the opinion, to summarize it, is it says that it is constitutionally infirm, INFIRM, not a term that we use a lot today, but essentially what he's saying is that it's crippled. It doesn't specifically, at least in the summary here, say that it's unconstitutional, although the Attorney General opinion tries to make the case that it is, but he uses the term constitutionally infirm. And then it says the separation of powers doctrine set forth in Article 2, Sections 1 and 2 of the Tennessee Constitution prevents the General Assembly and the governor from nullifying unconstitutional federal action. Well, I will address that first. That's one of the main arguments, is that Tennessee's own constitution has a separation of powers, and that the bill, according to the Attorney General, impermissibly assigns to the executive branch and or the legislative branch something that belongs only to the judicial branch. Now, I hope that your listeners already know that the Constitution, neither the state nor the federal Constitution, make a case for the judicial branch being the only means of determining whether something's constitutional. So we know that that's not accurate, but I'll address why a little bit later. Then the second point that he makes is that the Supremacy Clause of the United States Constitution makes this unconstitutional or constitutionally infirm. And of course, I disagree with both of those. The idea of actually reading the Constitution and having the Constitution say what it means and mean what it says is something that lawyers aren't typically used to addressing or dealing with. They simply rely upon what judges say about the Constitution rather than reading the Constitution itself. And so I hope to bring some answers tonight to you by looking directly at the Constitution. And then I'll also address some of the opinions that were expressed in the Attorney General's opinion by way of case law that was cited. So, Dave, first of all, let me ask if you understand the opinion to be, the Attorney General's opinion to be critical on the two bases that I've read also. There's a problem with state separation of powers, and then secondly, he says there's a problem with the Supremacy Clause. Is that what you understand as well?
Yes, that's the way I understood it.
Okay, so let's jump in on the first one. He put them in order. And so the first thing that he addresses, and I'm looking at it here, we'll read from some selective portions, but he claims that I'm looking at page 2 of the opinion that the Tennessee Constitution creates 3 separate and distinct branches of government: the legislative, executive, and judicial. Well, I'm going to give him a check plus on that one. He's right. That's exactly right. There are 3 distinct branches. And it says it allocates the powers of the government among those 3 branches. Another check. That's correct. He says the legislative branch makes the law. That's a check. The executive branch administers and enforces the law. That's a check. And the legislative branch interprets and applies the law.
You mean the judicial branch?
That's not quite a check. Okay?
Judicial branch, you mean?
I'm sorry. Yeah, what did I say?
You said legislative. You meant judicial.
I'm sorry. Yeah. Right. It says the judicial branch interprets and applies the law. Now, again, our Attorney General is within certainly the mainstream of legal thought, jurisprudential thought, who have been told that it's the judicial branch that has the authority, and in most cases, the exclusive authority to determine the constitutionality of an act of either the legislative branch or the executive branch. So the biggest hurdle that we have to overcome is to persuade people, including perhaps our Attorney General, that he's not read the Constitution exactly right. And without intending to be offensive to anyone, I just respectfully suggest, and it's going to be a bold statement, I'm going to respectfully suggest, read the Tennessee Constitution and show me the provision that says that. And I think he will be unable to do so. So I'm going to pull here from my resources a copy of the Tennessee Constitution. And our Tennessee Constitution addresses the branches of government. And as the Attorney General says, there are 3 distinct branches of government, no question. We have the legislative branch, they make the law. We have the executive branch, they administer the law, or in terms of law enforcement, they basically, I use the term, they capture and pursue and hold for trial those that would violate the law, but they're to see that the law is faithfully executed, upheld. And then we have the judicial branch. And the judicial branch, in my opinion, and I believe that the text of the Constitution bears it out, they simply offer opinions. They decide cases. That's far different than saying that they determine the constitutionality of any part of the Constitution. So I want to read from Article 6 of the Tennessee Constitution, which is called, the subtitle is Judicial Department. And it says in Section 1, the judicial power of this state shall be vested in one Supreme Court and in such circuit, chancery, and other inferior courts as the legislature may from time to time ordain and establish in the judges thereof and in justices of the peace. Well, that pretty much tracks exactly what our U.S. Constitution says about the United States Supreme Court. That is, in the United States Constitution, there is only one federal court that's created by the Constitution. That is the Supreme Court of the United States. Congress then, as the federal legislative arm, Congress then has the sole authority to decide if there are inferior courts, courts below the Supreme Court of the United States. And today it's difficult for us to imagine having a federal court system without there being other federal courts besides the Supreme Court. But it was not so from the beginning. Now, it wasn't long after the adoption of the Constitution that they passed legislative acts in the nation's capital to create these other inferior courts. But it's important for all of your listeners to understand that the Constitution itself does not demand that. Said another way, if the United States Congress chose to do it, they could abolish every single federal court except the United States Supreme Court, and they would not need a constitutional amendment to do it. Yeah. Now, let's go back to the U.S. Constitution as well, to use this by way of analogy. Under the U.S. Constitution, the Supreme Court has, in some cases, original jurisdiction, and in most cases, appellate jurisdiction. So let's go to the question first. Original jurisdiction would be the things that you don't file anywhere except with the United States Supreme Court. Your case gets filed first and only there, and that's the only shot you've got. The U.S. Constitution says that there are, however, cases that are appellate. And so the question would be, if there are no other federal courts, what does the Supreme Court hear appeals from? And so our founders established a system whereby states and federal courts would analyze the U.S. Constitution. Now, I want you to keep this point in mind because this is going to be an argument that goes to the second point about the supremacy clause. That is, the idea that the Supreme Court is supreme over everything, or that the federal government's supreme over everything. And so we'll be going to that in just a moment, but I wanted to let you see the two constitutions laid side by side. So remember, in the U.S. Constitution, what we have is we have the United States Supreme Court. Then we have it with its original jurisdiction, which is a very few issues, things like matters between ambassadors and other foreign entities and so forth. Most of the jurisdiction is appellate, and appeals from what or where? That would have been from state courts, because state courts were entrusted with the authority and the ability to decide United States Constitution issues. Right. Again, there were not inferior courts that were federal at the time of the adoption of the Constitution. So now let's go to the Tennessee Constitution. Again, it said in Section 1, the judicial powers vested in one Supreme Court and in such other inferior courts as the legislature may from time to time ordain and establish. So again, the legislature, the Tennessee General Assembly, that's our special name for the folks in Nashville, is General Assembly, whereas any reference to Congress is a reference to our federal officials in the nation's capital. So in our Tennessee General Assembly, they could, if they chose to, abolish every single inferior court and say, we're just going to have the Tennessee Supreme Court. I'm not here to make an argument that we should do that or that it's wise, but we're looking at what the Constitution requires. Now, it goes on to say, I'll skip a couple of sentences here in Section 1 because they're not relevant to our discussion. I'd like to focus on Section 2. This is Article 6, Section 2 of our Tennessee Constitution. It says the Supreme Court, the Tennessee Supreme Court there, shall consist of 5 judges. And so we'll stop there for a moment. The rest of it's not relevant to our discussion. We will go down to about 4 lines in my text here, about halfway through that Section 2. And here's the relevant provision. It says the jurisdiction of this court shall be appellate only, under such restrictions and regulations as may from time to time be prescribed by law. That is, the Tennessee Supreme Court has no original jurisdiction. They have appellate only. That's very plain. The jurisdiction of this court shall be appellate only, under such restrictions and regulations as may from time to time be prescribed by law. What this tells us is that, yes, there is a Supreme Court. They can hear appeals, but they can only hear appeals that are permitted by the legislature. The legislature can, very plainly here, put regulations and restrictions by law on what appeals the Supreme Court of Tennessee can hear. Yep. Then it goes on to say, but it may, that's the Supreme Court again, Tennessee, but it may possess such other jurisdiction as is now conferred by law on the present Supreme Court. Nowhere in there is there any language that says that they, first of all, have the authority to interpret the Constitution of the state of Tennessee outside of their own jurisdiction, outside of the cases that come to their courtroom. And I would be one of the first to say that it is not only their right, but it's their duty to determine the constitutionality of laws as it applies to the parties that are before them. Right. But with regard to determining the constitutionality of the other branches of government, I would argue that the separation of powers, as articulated by the Attorney General, would prevent them from determining the constitutionality of the acts of the other branches, because I believe that they are assigned the authority to determine constitutionality on their own behalf.
So that cuts both ways.
So, well, I mean, I think it's what it says. I mean, yeah. I understand what you're saying. I'm not trying to just find arguments. I want us to think seriously about what our founders really intended. Yep. And as you can see, it all seems to go back to the idea of the legislative branch, which stemmed from the people. And this goes back to a topic that I don't remember if I mentioned in my last podcast with you, but it's a common misunderstanding. I would virtually guarantee you that every member of the General Assembly, unless they've been to one of my courses or read it somewhere else. I'm not saying this idea is original with me, but they would believe that we have the checks and balances among our three branches of government, and that the idea is that they have equal power and that they play off of each other in a sense that the one branch keeps the other from getting too much power. There is a sense in which these branches have the ability to check the actions of the others, but nowhere in our state constitution, and I'll add also nowhere in the U.S. Constitution, is the Supreme Court of either of these jurisdictions, Tennessee or the United States. Right. Neither of them are given specific authority to declare unconstitutional the acts of the other branches or departments. So, with that regard, they've taken the power, and as I think I discussed earlier in our prior broadcast, the idea that the U.S. Supreme Court claimed this power for themselves in a case called Marbury versus Madison, issued in 1803. There was a case there about the acts of the president and whether the president could do what the president did. And there, what they did was they initiated, or they created, I guess I would say, the concept of judicial review, which claimed for the Supreme Court the power, or even for other federal courts, the power to review all the actions of the other branches of government and to declare what they've done either to be constitutional or unconstitutional. It's my opinion, and I believe it's well founded, that the Constitution did not give them that authority. It's my opinion that they exceeded their authority by claiming the sole and exclusive authority to be the final arbiter of those things. Let's ask ourselves the question about why we require members of the General Assembly in Tennessee to take an oath that they will support the Constitution, that they will support the Constitution of the state of Tennessee, that they'll support the Constitution of the United States. If their oath did not mean anything, if they weren't to determine whether something was constitutional or not, then what's the basis of making them take such an oath? The same would be true for the governor. Why would the governor take such an oath to follow the Constitution if he was not expected to know and understand? If we're just going to let the courts of the state of Tennessee decide these things all the time. So I believe that both historically and logically, it's a logical, simple, plain reading of the Tennessee Constitution would tell us that there is no specific authority. It's certainly not set out. It's not delineated, enumerated anywhere that the Tennessee Supreme Court can decide the constitutionality of other branches of government. In fact, remember again, their jurisdiction is appellate only, and as may be determined by the General Assembly. So there we go. That goes back to the idea: are the branches equal? And my answer is no. The strongest branch of both the federal and the state government is the legislative branch. They have power to fire. Go back to the U.S. Constitution. Congress can fire the president. That's called impeachment. Right? Impeachment and removal, or impeachment and conviction. And of course, that's become fairly well known in our lifetime because it's been attempted several times. No one's been removed yet. Several been impeached, but no one's been removed from office. Right. But again, the Congress has the power to fire, essentially, the executive branch, any member of the executive branch.
Or a Supreme Court member.
That's right. I started to say what's not as well known is that they may also fire judges. They may remove them from office. In fact, judges have been removed on the federal level.
Not enough, but yes.
Even during my lifetime, federal judges have been removed. Now, I'm not aware of there being any United States Supreme Court member being removed, but that's possible. So the question is, are the branches really equal in power? If one branch can remove any member of the other two, and the answer has to be, if we're being honest, no. There's not that authority to remove. They're not equal if one branch, the legislative branch, can remove members of the other. Now, Dave, the same is true in the state of Tennessee. There's impeachment, the concept of impeachment, and the General Assembly can remove the executive or any members of the executive branch, and they can remove any members of the, as we just read, they can remove any members of the judicial department. So what our Attorney General opinion is based upon is custom. And in all fairness, I want to defer. I'd be the first to say that the custom has been that, yes, the Tennessee Supreme Court decides what is constitutional, but custom does not rewrite the Constitution. And my point is that there is no explicit language anywhere giving the authority to the courts to determine the constitutionality of the acts of the other two branches. His articulation here about why this can't be done because of separation of powers fails to understand the actual text of our bill. This bill keeps it certainly within the lanes that each should travel in. So the bill, let me find a copy of our bill here. With regard to what it says that the different departments of government can do.
I think it's in section 9, I think, is where it starts with the.
That's right. I think you're right. We get section 9. And so it says here, the governor may, again, the section 9 talks about how we accomplish nullification. And we never tell the governor he can do anything except within the executive branch.
Right.
That's what our bill says.
Right.
So how he can say that it's unconstitutional to allow the governor to decide whether something's constitutional within his own branch, and that he can't even do that without going to the Tennessee Supreme Court, does not make sense to me. He took an oath.
Right.
If someone wants to challenge, I mean, in all fairness, if someone wants to challenge whether the governor was right with regard to his action to nullify something, it may be that eventually winds up before the court. But in my opinion, his right to determine the constitutionality of federal action with regard to his own department, it lies squarely underneath his jurisdiction.
Well, couldn't the legislature, let's say the governor said something was unconstitutional and he nullified it within his executive branch. If the legislature thought, well, hey, you're wrong, governor, I mean, would they be able to? I mean, I know that in our state, we don't have a strong governor by the Constitution. A simple majority can override the governor's veto, for instance, and it only takes a simple majority to pass legislation. Would they not be able to basically undo his nullification if they felt like he was wrong?
I believe that they could.
Okay.
I think you're absolutely right.
Okay.
So under this, as you've said, let's just make sure your listeners, they may not have a copy of the bill in front of them, but it says the governor may, by the governor's own executive authority, issue an executive order nullifying the same, whereby all executive departments of the state are bound by said order. We're not claiming that he can do anything to bind the legislature or the courts. He can simply nullify it in his lane, and he's the chief executive. And so now to go to the second issue, what if the legislature disagrees? Well, they can say, Governor, we think you've missed it, and so we're going to pass a law. Now, of course, then he has a right to say, I don't agree with you. He can do like Andrew Jackson did and said, you know, I don't agree with you. I think I do have the authority, but they can override that.
Yeah, simple majority.
Same vote as before, right?
Yeah.
What it took to pass it the first time is all it takes to override his veto.
Yeah.
So again, showing that the real power lies in the elected branch, that is the executive or the legislative branch, the General Assembly of Tennessee.
Right.
So I don't agree with the Attorney General's application. Maybe I won't say I don't agree with his reading, but I don't agree with his application that our bill permits the governor to do something that's not constitutional. In fact, it's his duty to see that he acts only constitutionally.
Yep.
Not only as it pertains to Tennessee Constitution, but also as it pertains to the United States Constitution.
Yeah.
Now, Section 2 of our bill, and Section 9, Section 2, has to do with the General Assembly introducing a bill of nullification. And this is where I think our Attorney General has specifically focused in on the fact that, well, the General Assembly can't decide what's constitutional, only the courts can. And they can't make a law declaring something to be unconstitutional. But again, or they can't pass a law stating that they believe. I don't know what his position would be on a resolution, but they, as you said in your introduction, they've already passed resolutions nullifying some COVID mandates.
Right.
I don't know that any court in the state of Tennessee came along and said that they couldn't do that.
And just to clarify, I'm not sure that resolution, like most resolutions, it doesn't have teeth. I think that resolution was more of a letting the federal government know on certain issues, okay, hey, if you do this, if you mandate X, Y, Z, and this was in relation to COVID, but it would stand for anything else that may come down the pike. They said we have not only the right, but the responsibility because of our oaths, and we're not limited to court action.
That's right.
Yeah.
And I agree with you on that point, that resolutions do not necessarily have the same force and effect of law.
Right.
And so, but I just wanted to point out that, again, a broad reading of the Attorney General's opinion would be that they didn't even have the authority to do that.
Yep.
I mean, I'm trying to be fair to all parties here. I think that he might say that they don't even have authority to offer opinions about that, because he says, the exclusive purview of the judicial branch, or at least that's what he says the case law says. And I don't agree. Respectfully, I disagree.
Right.
I think both historically and a logical and reasonable reading of the Tennessee Constitution would say that he's incorrect, that no other branch of government can even consider or make any determination about constitutionality. So, all right. So Section 2 of our bill, Dave, of course, just goes through about how they do it. He doesn't really address any of the procedures, protocols. Maybe he feels like it's not necessary. Maybe his opinion is that since the whole thing's unconstitutional, it doesn't matter about small bites. But as you know, there are different ways that things get to the General Assembly. So the General Assembly themselves can raise an issue. Speaker of each house can, as you know, also 10 cities or counties through their legislative arm or through their executive can ask that something be voted on. And then citizens can also make application to have the General Assembly consider whether federal action is constitutional or not. So everything runs back to this Section 2 with regard to that. But also, I want to point out that in our bill, we don't ignore the courts. We say the courts have a role. And we think that the role the courts have in our bill is the proper role, which says that what if the legislative branch, what if the General Assembly doesn't take any action on something that's arguably beyond federal control? What if the executive doesn't do it? Well, Section 9, sub 3 of the proposed bill says any court operating under the authority of the Constitution of Tennessee may render a finding or a holding of nullification in any case in which it otherwise has proper venue and jurisdiction, wherein the parties to said case will, upon final judgment, be bound thereby in the same manner as in other cases. This is consistent with what I believe the true role of the courts are. The true role of the courts, any judge, his role is to decide the matter before him and not to control other branches. And one of the things that I hope the members of the subcommittee and the Senate and the House that we'll be talking to tomorrow, potentially tomorrow, on these topics, that they will consider is that just consider for a moment. Let's take our United States Supreme Court for just a moment and think about some of the most difficult issues, perhaps divisive issues that we ever have with regard to government scope and control. And if they're saying that ultimately the Supreme Court is the only entity, the only federal entity that decides what is constitutional, that means the power is vested in 9 people. Yep. And again, in that particular case, unelected, appointed, and ratified or confirmed by the Senate. Our founders would never have agreed with such a concept. And all one has to do is read the Federalist Papers, read many of the early cases in our nation's history. No one believed that the Supreme Court of the United States had such power. The General Assembly is where everything starts. I hope that makes sense to your listeners. If there's no law about it, then there's no law for the executive to enforce. And if there's no law about it, there's no case for the court to hear. That is, they must arise under the Constitution of the United States. And here in Tennessee, the Judicial Department simply hears cases with regard to the litigants before them. And that's as far as their opinions extend, in my opinion, just to the litigants before them. So he goes on to say here, his source for the phrase of the judicial branch interprets and applies the law, and I'm going to underline that on my copy. He cites Richardson versus Tennessee Board of Dentistry. So I pulled that case today. It's a bit of a lengthy case, 18 pages, I believe, as I pointed it out here, printed it out. But and again, I wish I had things better prepared. Maybe for you, give your listeners, the viewers,
you're fine.
Text. We're operating on less than 24 hours notice in many cases.
I know, and you're doing great.
So in Richardson, a 1995 Tennessee Supreme Court case, the question came up about whether an administrative agency could determine whether something was constitutional or not. And so the bullet point, what we call head notes, I'll just show you the case here. I've got it here in yellow. But the head notes for cases are a summary by editors. It's not the actual case, but editors read these cases and then categorize them. So I'm just going to read the head notes for now. They're almost always spot on. But head note number 1, in this case about the Board of Dentistry, says, general rule is that administrative agency may not determine constitutional issues and is not authorized to consider or question constitutionality of legislative act or to declare unconstitutional statutes which it was created to administer and enforce. Well, that's basically, I think, correct. They're saying that the governor and no one under the governor's authority, those should be the administrative agents, they can't say something's unconstitutional. Okay, so I agree with that. The general rule is that administrative agencies can't do that. Well, then one of the other head notes says, this is head note number 3, it is the sole obligation of judiciary to interpret law and determine constitutionality of actions taken by the other 2 branches of government. Now, that is directly on point. That's what the Attorney General would rely upon. He's going to rely upon that head note. It's the sole obligation of judiciary to interpret the law and determine the constitutionality of actions taken by the other 2 branches of government. But that's not really that's what we would call dicta in law. Sometimes courts give opinions that aren't necessarily related to the decision before them. In this particular case, the issue was whether the Board of Dentistry could decide something's unconstitutional. And in commenting that no, they can't, the court just kind of walked a little bit off the path and said, only the judiciary can decide what the other 2 branches do, which is not really the question here. Okay? But to the extent that head note from the 1995 case says it's the sole obligation of the judiciary to interpret the law, interpret the law in that case, yes. But then it says determine the constitutionality of actions taken by the other 2 branches of government. There is no constitutional support for that statement. It's just a bold assertion that maybe has been custom,
right?
But show me in the Constitution where you can support that.
Yeah, custom is not constitution.
Correct. Right. Now, head note 5 in this same opinion says, while the doctrine of separation of powers is fundamental to our form of government, and that's Attorney General's argument, separation of powers. They said, while the doctrine of separation of powers is fundamental to our form of government, it is not absolute. And it does not require that administrative agencies never consider constitutionality of administrative action. So the very case he cites, in which they say it's the sole obligation of the judiciary to decide this, the same opinion says, but it's not absolute. The separation is not absolute. So they can still think about it. They can consider whether something is or is not. In the same case that he cites for the fact that the executive branch can't do it also says, but they can do it within their own departments, which is all that we're saying.
Right.
That the governor can decide that within his own branch or department. And let's see. There's I think that was the only thing I felt significant in that case. The next case that he cites is Underwood versus State. And so Underwood versus State is a 1975 Tennessee Supreme Court case. And this case specifically says, head note number 3, and again, you know what the head notes are, so I've got the head note highlighted there. It's just a summary of what's later in the opinion. Right. It's a short opinion here. It's just 3 pages. It says, legislative enactment, which does not frustrate or interfere with adjudicative function of courts, does not constitute impermissible encroachment upon judicial branch of government. Well, that case says, as long as the thing can still go before the courts, even if we want to accept that the court has this role, it's saying that a legislative enactment that does not interfere with the courts to decide something is not impermissible. Now, I'm going to take the position that a court cannot overrule what the legislative branch does. And our attorney general will probably disagree with me on that. I still believe I'm right, respectfully. But this case says that they can still do it as long as it can eventually get to a court for a court to decide. And so the case, the Underwood case that he cited here specifically says that if it does not frustrate or interfere with the adjudicative functions of the courts, that is, if the courts can still decide something later, it's not impermissible. So I think that's kind of spot on.
Decide or be the final arbiter?
This case doesn't say.
Okay.
The case doesn't. It just says if it does not frustrate or interfere with the adjudicative function. This would not frustrate the function. It would not interfere with the function.
Right.
Anyone who says, I don't think that the Tennessee General Assembly has the authority to nullify this action, and they feel that they're aggrieved by it, including even the federal government, or a federal agent can come into Tennessee and try to file something within the Tennessee legal system, they would still have recourse to get that very matter before the courts. Now, again, my position is a court can't nullify the act of nullification by the General Assembly.
Right, right.
But for him to rely upon this case to say that the legislative branch can't even consider it, that's a violation of separation of powers, this case goes directly against that concept, if that makes sense.
Yeah.
You follow?
Yeah,
Okay.
absolutely.
All right. And then he cites later on, he cites the city of Memphis versus Shelby County Election Commission. And it again has to do with an election commission. Here, in this case, the election commission tried to decide that a ballot initiative was not constitutional. And here the Tennessee Supreme Court says election commissions can't decide whether to put something on the ballot or not. Right. And so I think they rightly decide that that's not a county function, certainly not a county election commission function to decide. The citizens can vote no on it if they think it's unconstitutional. But there's some language here too. Head note 5, county election commission may not refuse to include a referendum question on the ballot because the commission believes the question to be substantively unconstitutional. This same, I think maybe I could bring this one up if they want to give me time. This same opinion that says attorney general opinions are not adjudications. So this very case says that his opinion is not determinative of the matter. It's simply an opinion. Right. Hey, let me go back to the Underwood versus State again. I found that this part of it wasn't in a head note. Have to read the whole opinion to find it. But it says here specifically, it has long been recognized that it is impossible to preserve perfectly the theoretical lines of demarcation between the executive, legislative, and judicial branches of government. There is necessarily a certain amount of overlapping. The three departments are interdependent. The Constitution, and this is the Tennessee Constitution, does not define in express terms what are legislative, executive, or judicial powers. Theoretically, the legislative power is the authority to make, order, and repeal. The executive, that to administer and to enforce, and the judicial, that to interpret and apply laws. Well, interpret and apply laws is certainly fine with me. I don't disagree with that. They do interpret and apply laws, but they don't declare actions of other departments unconstitutional. Again, this is an opinion cited by our Attorney General. It's on point in some respects, but this latter section here basically says that there's no clear line between what belongs to what branch. And so I really believe I can take the Attorney General's opinion here and use it against him. If need be, because it says there's no clear lines. And of course our other the earlier head note that we read there about as long as it doesn't interfere with the courts, then the branches can do it. So those are my thoughts. Again, I could spend more time, but those are the main thoughts about his argument number one: separation of powers under the Tennessee Constitution do not permit it, and just respectfully, I disagree. For easy reasons. Number one, the cases he cited do not make a bold line there, do not say it's absolutely impermissible. If they did, they would be wrong, respectfully, but they don't say that. They don't say quite as much as he wants them to say. But then secondly, go to the Constitution and show me that. So certainly one branch may not take on the functions of the other branches, but who said it was the function of the judicial branch to declare the constitutionality of things? Nothing says that. Not one word of our Constitution says that. People say, I've often said that nullification is a thing, and they say, that's not in the Constitution. You can't do that. And my answer is, you're right. It's not in the Constitution, but I can do it. The Ninth Amendment says if the right is not set forth in the there it is on the screen. You have the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So therefore, if it's not in the Constitution, we have the right. So since nullification is not mentioned, we have the right of nullification. And then the 10th Amendment, that was on the screen earlier I saw, talks about the powers, and the same issue there. If the power is not delegated to the United States by the Constitution, or the power is not prohibited by the Constitution to the states, they're reserved to the states, to the people, respectively. So the Constitution says we have both the right and the power to nullify,
Right.
because it's not mentioned.
Yeah.
That's easy rational. That's logical. It's good rationale.
Yeah.
So I don't know how anyone can really argue that. So again, if your listeners, viewers are the first time on this issue, just rest assured that that's a sound argument.
Yeah. Essentially, and this is kind of a quick summary, in my opinion, if you look at Article 1, Section 8, that lists the powers of the federal government. There's mainly 18. There's a few powers in other places in the Constitution that have to do with, for instance, impeachment, so on and so forth, electing a president when the election is, there's no clear winner or whatever, and thrown into the House. But most of the powers of the federal government are in Article 1, Section 8. Article 1, Section 10 says things states can't specifically do. And the reason we have 9 and 10 is to remove any doubt that that's it in terms of power. The power that they have, the federal government has, is in Article 1, Section 8, and the things specifically the state can't do are in Article 1, Section 10. Everything else is supposed to go with the states.
I don't know how we're doing on time, but we've got the Supremacy Clause. And
yes, please hit it.
Okay, want to hit it? Okay,
yes.
So Supremacy Clause comes from Article 6 of the U.S. Constitution, and our Attorney General offers the opinion, as most lawyers believe, that's what they're taught. We've got it there on the screen, that we're going to look at the important section there, paragraph 2, which says this Constitution, I'll just read it off the screen here, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. Well, the Constitution is the supreme law of the land, not the federal government, not the Congress, not the president, not even the Supreme Court. It's the Constitution that's the supreme law of the land. Let's ask ourselves the question. Did we just read the 9th and 10th Amendments to the Constitution, which say that the rights not delegated, enumerated, that the powers not delegated in the Constitution are reserved to the people? Then that's supreme. So the Attorney General, as most lawyers do, they read the Supremacy Clause in a way that they claim that it means the federal government and whatever it says or whatever it claims is supreme. But the actual language says that the Constitution itself is supreme, that laws made pursuant to the Constitution are supreme, and furthermore, even treaties that are made under the authority of the United States. Remember, if the people did not give the United States the authority for treaties in certain areas, those are illegitimate as well. So, whereas the Attorney General says the Supremacy Clause acts against nullification, it's very clear, it's very plain that nullification is on our side. Yep. Nullification is supported by the Supremacy Clause because it's the Constitution, specifically Amendment 9 and Amendment 10, yep, that say that we have the right to do it because we still have the power and we have the right. Yep. So it's just a misreading. But again, I want to try to be fair to all lawyers out there. They're not taught this in law school. No. We're just shown cases where the Supreme Court says that they've got the authority to do this stuff. They claim it. They go all the way back to 1803 and Marbury versus Madison, and the Supreme Court claimed judicial review for itself, and so it's custom. Yeah. But there's not one word in the United States Constitution that says that the court system, any federal court, even the Supreme Court, not one word in the Constitution that says that they get to declare acts of the other branches of government as being unconstitutional.
My closing remarks, and these are mine. You don't like what I say, you contribute it to me, not to Jeff. Okay, and I'm going to take this from Section 2. I'm sure he'll agree with this. This is Section 2 from our Declaration of Rights in the Tennessee Constitution. That government being instituted for the common benefit, the doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. The AG's opinion is more of the same, surrender and bow to the Fed's mantra. Let the legislators, especially on the Senate, State, and Local Government Committee, know this does not give them cover just because you got an opinion from the AG. We expect you to uphold your oaths.